Good morning, counsel.
Good morning, Your Honor. May it please the Court. The salient facts and status of the case here is that the defendant, Bader al-Saud, was indicted in December 2002 for motor vehicle homicide. He pled guilty in November 2005.
Why did it take so long?
What's that?
Why did it take so long?
Well, criminal cases sometimes take a long time. There were a number of issues that had come up and were discussed with the district attorney's office, and we finally took a while to work out a plea on the case.
Pretty good plea.
We thought it was a good.
Now, is there any case that you can cite for me in which we have agreed to hear on appeal a preliminary determination of a violation of probation that justifies a arrest warrant? This is not a final finding of a violation, nor is it a revocation. It's just a preliminary finding.
Right, but I think if you read the Duggan versus Commonwealth case, you can infer from that where there's even where there's collateral consequences and where there's no real further action that's going to be taken on this case, that it's ripe for appeal at that point in time.
Why is there no further action that's going to be taken? If he returns to this country, he'll be arrested, he'll be brought before the judge, there'll be a hearing as to whether there should be a violation of probation, and isn't it then when it's ripe for us to hear it?
I would say no, that as long as he's got the default warrant on, there's collateral consequences, whether he returns or not. He was ordered not to return to the country.
He's not even in this country, so what are the collateral consequences to him?
Well, the collateral consequences are that it's on his record, and other countries look at that. If he wants to travel, they might look at that and say he still has an outstanding warrant out for him.
But it's within his power to come back and clear it up.
It wasn't within his power to come back and clear it up. In fact, he was told that he could not come back. And
well, he can
that's
come
one
back
of the
with
reasons.
ICE's, he can come back with ICE's permission, correct?
What's that?
He can come back with the permission of ICE.
He could come back with the permission of ICE, but they said they weren't going to give him permission. That's the last thing that was said about it, is he was not going to get any permission to come back. Furthermore, I think if you look at there are other cases cited in our brief with regard to that this case is ripe for appeal on the basis that it's reached the point where, while it's not a final order, there are cases, and I mentioned Duggan, where the normal appellate procedure is appropriate for a probation violation ruling when there is no adequate alternative. And I would suggest to you, in this case, there really is no adequate alternative. We also cited other cases, Benoit versus Samuelson, Brault versus Fredrickson, and Brum versus the town of Dartmouth.
Okay, I gather he has not sought permission from ICE to return to this country.
No, he hasn't.
And if you prevail, and if he seeks that permission and is granted, he comes back tomorrow, and he's no longer on probation when he otherwise would have been.
Well, his probation, the fact is that the probation department did not send him any notice of surrender until 12 days before his probation would have been up.
Presumably there was a tickler that came up and somebody said, oh my, his probation is coming up for termination. We don't have any record of anything.
Well, I don't know if it was a tickler or not. I think they might have been tickled by someone outside the probation department who had interest in the case either.
But why does that matter? I mean, what's...
Well, it doesn't. But what it matters is that the fact is probation was almost over, and there's other cases, not in this state, but other cases where it's been held that it makes no sense when someone is out of the country to just continue the probation indefinitely. First of all, keeping the case alive, in fact, just adds to the administrative requirements that probation has. It seems to me that they have enough to do in trying to
Isn't that their choice, not yours, though?
what's that? Your Honor?
I mean, maybe they do have enough to do, but isn't that really their judgment to make, not yours?
Well, there actually is case law about the fact that I think it's the Balagun case where they talk about, that's cited in our brief, it's a waste of resources for the probation office to issue a default to a probationer that has absolutely no need of the services, and it's a disservice to the purpose of probation to keep it going for no good reason.
But
He's not going to be supervised.
But isn't that an argument that you should have made by seeking a modification or a termination of probation when he was still in this country and letting the judge decide that, as opposed to saying, allowing him to go to Saudi and then after the fact, now that he's safe in Saudi, well, now we'll hear whether we'll get a dismissal, and if we get a dismissal, then we'll urge you to come back. If not, then you won't return to this country. I mean, isn't that sort of a strategic choice that you made, and why should you benefit from that?
Well, Ron, I think, first of all, if you look at the principles articulated in the Poirier case, which was decided in October this year, that it's not the the probationer's responsibility to inform probation when he's being released from custody. That's number one. Number two, even if we had that obligation, we provided notice to probation and to the district attorney's office and to the court that he was planning to leave the country.
When did you do that?
We did it twice.
When?
Number one, we did it in the sentencing memorandum at the time that he pled guilty.
You said you were going to seek it, right?
What's
you said
that?
you were going to seek it.
Right, we were going to seek it. And then in June of the year, right before he was released, I think it was June 8th, we filed a motion for release of passport to counsel. In that motion, which was assented to by the district attorney's office, we articulated exactly what was going to happen. If you look at it's in the record, and if you look at it, it's section 4 of that motion, item number 4. We state that he's going to be transferred, his custody's going to be transferred to ICE. He's going to be taken to the airport, placed on a plane, and sent back to Saudi Arabia through what is a term called voluntary departure, which isn't really voluntary, but that's the term that's used. So they had notice of the fact that he was leaving prior to the time that he was paroled and prior to the time that he actually left.
But, Mr. Rosenfeld, the fact that they may have noticed that that was your plan, they know there's a that the sentence is he has a from and after probationary sentence. You say, well, we're going to do this other thing. Isn't the obligation on you to say we need to get that modified? It's not their obligation to say, oh, look at what you're doing. You can't do that.
When as I mentioned, probation was aware right from the beginning when he pled guilty of the fact that what the intention was. Probation had the obligation, not the defendant, to put instructions in the probation contract, so-called contract, articulating what he should do if he was going to leave the country, that he should file something. All they said was, don't leave the country without the permission of the probation department. He had no choice. One of our arguments, by the way, is that he had no choice about leaving the country. He was taken out of the country.
But the judge wrote this. The defendant planned his departure from the country at least 1 month before he left. Before he departed the United States, the defendant could have contacted the probation office to ask for modification of the conditions of his probation or sought clarification from the court concerning the effect that his hasty departure would have on his probationary status. The defendant chose to do neither. Do you dispute any of that?
Yes, I do. I think that he did not have that obligation. He did provide notice that he was leaving the Commonwealth in the motion. That motion, by the way, was not only assented to by the Commonwealth, it was handed to the probation people in Suffolk County Superior Court probation system. They, in return, handed back the passport that they were holding. If they didn't know he was leaving the country, they had to be blind and deaf and everything else. They knew he was going. It wasn't any secret. No secret. It wasn't. He didn't leave the country in secret. He didn't abscond. He wasn't a fugitive where he fled the country. In fact, what happened was that he was deportable. He was a deportable alien because his student visa had expired and he'd committed a crime. ICE put a hold on him. When paroled him in June 2006, they paroled him to ICE, in fact, and he sat in the Dukes County House of Correction for extra days until ICE was prepared to take him.
But that was all part of your negotiation with ICE and parole board, right?
I'm sorry.
That was all part of your negotiation with ICE, that there would be this voluntary departure on business class to England and then Saudi Arabia as opposed to being deported.
Your Honor, I would suggest to you that voluntary departure isn't voluntary. The only thing that's voluntary about voluntary departure is the method by which you're going to leave the country. Whether you're going to leave the country, when you're going to leave the country, and is all at the direction of ICE. ICE made it clear that he was not to leave custody until they picked him up. He was paroled as of July 10th.
It's not voluntary departure in what we would ordinarily think is it's voluntary in lieu of being deported.
Right.
And essentially, you're held in ICE's custody until they arrange a date for you to depart voluntarily.
Right, and voluntary departure, and while there's no case law in Massachusetts on the issue, there's a whole series of federal cases holding that voluntary departure is the equivalent of deportation. And we've cited them in our brief. Lynn, McKernan, Tyson Foods, there are several cases.
Mr. Roosevelt, I would like to go back to something, though. I guess I read the judge's decision below to include a finding that, in fact, the probation conditions were violated. Not a preliminary finding, a finding. Now, whether the next step is whether the judge is going to revoke the probation or dismiss the probation or modify the terms of probation, but hasn't the judge made a finding of probation violations?
Yes.
Yeah. I'm satisfied that sufficient grounds exist for the issuance of a default warrant for the defendant's arrest based on his violations of probation. So with respect to these violations that were noticed, you say the costs that were required to be paid were paid?
Right.
Right? So that was not, so there was no, I don't know when they were paid. Maybe they weren't paid timely.
They were paid when they issued the surrender and they brought it up when the hearing before the judge.
Okay. Another one in the final notice says the failure to provide a DNA sample. Now, I suspect the law requires that, but I don't see it in the probation contract.
I don't either, and that's the responsibility of who's ever supposed to take the DNA sample, not the defendant to go and say, I want to give my DNA to you. I mean, that's a requirement that either the corrections department somehow has or the probation department to do it. That's not the defendant's obligation.
And what you're suggesting is the requirement that you essentially physically report to the probation department was something that was impossible in the circumstances.
Exactly. It was an impossible, and I would suggest to you that the judge was wrong. She made an error when she held that it wasn't impossible for him to report. As I mentioned, he was incarcerated from November 19th, 2005 until July 20th, 2006. On July 20th, 2006, ICE representatives drove down to the Dukes County House of Correction. His custody was transferred to them at that time, and he was driven directly to Logan Airport. And they put him on the plane and made sure that the plane took off. I was there. I saw it happen. He was never out of the custody of ICE at that point. And to say that he should have reported, and that's where she found the violation, by the way, was he should have reported to probation upon his release from custody. In fact, he was never released from custody until he was taken out of the country.
Okay, but respectfully, you know that for finding a violation of probation, there has to be a probation hearing and certain rights presented, and you're not coming before us and saying that his constitutional rights with regard to a finding of a violation of probation were violated, because you understand that this is not a final finding.
No, I would say that his due process right was violated, and if you look at the McCool case...
This is not a final finding of a violation of probation. Do you agree with that?
I agree with that. But nonetheless, because the default warrant was issued, his due process rights in the McCool case, this court said that even when a judge exercises discretion in a probation finding, it can't be arbitrary, and it can't not have good reason. In this case, under these circumstances, which I will agree are very unique, under these circumstances, it was the judge violated his due process rights under those circumstances.
Mr. Rosenfeld, we'll have to leave it here.
Thank you, Your Honor.
Good morning. May it please the Court, John Zanini for the Commonwealth. With me today is Assistant District Attorney Jennifer Hickman, who handled the plea and was present at the preliminary surrender hearing, at which there was a preliminary determination of default and a warrant issued because the defendant was not present in court, as Judge Hinkle found. I would like to point out and reemphasize the fact the case is not ripe. If you allow a defendant to appeal a preliminary determination of default and the issuance of a warrant, there will be tens of thousands of appeals that are now ripe.
Well, we certainly have the discretion to do that. And there's also the denial of the motion to essentially end the probation, right? I mean,
Which, if as a matter of, it sort of seems to me there's a two-way street here. You can't say the court can act on my motion to dismiss, but on the other hand, cannot hold me accountable for my failure to report, my failure to be in court, my failure to fulfill any of my obligations at all whatsoever. You can't have your cake and eat it too. And every time the defendant has an obligation that serves his interest to fulfill that obligation.
Yeah,
or
this
to
is very
undertake.
curious. This is very curious to me, though. If you read the paperwork, the sentencing memoranda filed by the defendant, the sentencing memoranda filed by your office, the motion to secure the passport, it seems very curious that you're taking the position, whoa, we wanted him to stay in the United States. We want him to report to the probation department. You wanted him out. That was part of the deal. He agreed he wouldn't oppose deportation. I mean, that was part of the deal. I don't understand why all of a sudden you're saying, he left the country? He forgot to tell us? That seems so inconsistent with the entire nature of the deal.
He has an obligation to the courts of the Commonwealth and the people of the Commonwealth that he asked, that he voluntarily undertook. Having undertaken a voluntary obligation, which included reporting to the court and being on probation, he is not at liberty then to simply act in utter disregard of that. Although there was a future...
So you didn't know that he was getting ready to leave, that he had made the arrangement which had been agreed
Correct.
to, that he would voluntarily depart
No,
the country?
if you read the Commonwealth's plea agreement, we said we would not oppose his pursuing voluntary departure. I believe that was the language in our memorandum. Sure, people were aware there was a future contingent event which might occur, which the federal government was in control of and Mr. Al-Saud was in control of. It's completely outside of the control of the state, of the Commonwealth of Massachusetts. And we were not on notice when the future contingent event became actualized and became real, and the only person who could put us on notice was the defendant, and he didn't. He didn't put the court on notice that he was about to walk away from his probationary condition.
Your recommendation is the defendant shall not oppose voluntary departures. That was your recommendation. He shall not oppose voluntary departures.
Which is an awkward wording because, in
Well, it
fact,
is.
he must actually pursue voluntary departure.
In lieu
He
of
must
deportation.
pursue it. Correct. And it's advantageous to him because if you voluntarily depart, you can reapply for readmission at any time in the discretion of the Attorney General. If you're deported, on the other hand, and involuntarily removed, you have to wait a minimum of at least 5 years. And so it's advantageous to him to voluntarily depart, which is fine. But the question is, can people just ignore their obligations to the judiciary of the Commonwealth of Massachusetts?
You say that the motion for access to passport, as Mr. Rosenfeld described it, and sort of laying out what at that point, it was still contingent, but it was very close at hand. Did you say that didn't give notice? I'm not saying you had an obligation to do anything, but don't you think that gave you notice?
He had an expired passport, which he wanted his expired passport
But
back.
didn't
You
he
can't
explain
travel
what he-
with can't travel with an expired passport. Did it give some level of notice to the court that he was continuing to seek to arrange his departure? Yes, but he walked into court with his motion and said, "Hey, can I have my expired passport back so I can go get it renewed, so I can continue to make arrangements, so that I can leave and go to my home country?" That's fine. But clearly, he knew where the courthouse was. He knew how to go to court. As he said, he's the one who handed the order to probation, and they handed him his passport. He knows where the court is. This is not some sort of, what a surprise. I didn't know where the court was. I didn't know there was a probation department.
But
Mrs.
the
Zanini,
consequence, I'm sorry, the consequence of your assenting to that motion is that you lost the ability to control what happened. Because
No.
as long as he didn't have a passport, then he couldn't have been deported or voluntary. I mean, he could not have been voluntarily surrendered.
Right.
So that was the control that you had, and you gave that up.
Well, don't look at me, because the probation department
But you assented
is
to
not
it. I mean, the
correct.
Commonwealth assented to it.
Correct, and a judge ordered it, but a judge could have withheld it. A judge could have denied that motion. The probation department does not report to the district attorney, and this is not on the district attorney that we assented to him having the passport. Also, there's a misconception that he couldn't leave without that expired passport being returned to him. That's not true. It would take him longer to get a new passport issued without his expired passport, and he would therefore be in the custody, in all likelihood, of ICE, maybe in the same facility, maybe in a different facility, sitting incarcerated while waiting for that passport. Or he could be bailed while waiting for his passport, and once he was bailed and at liberty, awaiting the new passport and awaiting removal or departure, he would then have been subject to probation. So
Well, certainly,
there
but he was
there-
never bailed. He was never released. He was handed over to the custody of ICE, was put on a plane and left. Now, let's assume he was deported. What's your view? Still violated probation?
My view is that we must be very careful about the purposes of probation and the usefulness of probation for all of the persons in the Commonwealth who are subject to criminal charges and whose criminal disposition may result in deportation. The purposes and goals of probation, as set forth in the Power case in 420 Mass 410, are punishment, deterrence, retribution, protection of the public, rehabilitation of the probationer. And probation is an alternative to incarceration. If we're going to take the view that the superseding conduct of the federal government, which will terminate probation, not stay it, not put it in abeyance, not hold it off until the person returns, perhaps someday, then if the federal government is going to step in and supersede our probationary orders and simply terminate them, and they're an alternative to incarceration, and if that's going to be the policy of this court, then there's a real danger that probation will cease to have any usefulness for people who are subject to removal and who
Well, would you agree with me
who
that
will
if
be
you are
removed.
deported, it is impossible for you to report to your probation officer in Boston?
As a personal matter, you can't personally show up. I would agree with that. You could ask your attorney to go to the probation officer, to go to the court, and to take steps on your behalf. Not only that, if you are the one person who knows for sure that you are leaving, on a first-class flight, not business class, if you look at record page 61, on a first-class flight to London, and if you know that, then, and if your attorney went and got your expired passport for you, and if your attorney has arranged all of these things for you, you can certainly have your attorney or some other representative or some other agent go back to the court and report before you leave. This is not an onerous obligation.
Has the policy of ICE changed? It at least used to be that the federal government didn't interfere until someone had completed his or her sentence. We have another case. I mean, has the federal government now changed that they step in before the punishment is completed?
I'm not aware of any change. I'm not aware, first of all, of any formal policy on whether they let people finish their term of incarceration. They certainly can remove people before a case is completed or before incarceration is completed.
Another question is, given your sentencing memorandum, where both parties seem to be aware that he might leave the country, and the judge, therefore, was presumably aware of that, could one argue that the judge nevertheless imposed probation and arguably did so only in the event that the defendant did not leave, since everyone seems to have been aware at the time of sentencing?
I would suggest not, because it's a future contingent event over which the court had no control and the district attorney had no control.
No, but since it was clear to everybody that he might leave, could one argue that the judge imposed these terms of condition only in the event that he did not leave?
I don't see that anywhere in the probation conditions, in the contract, in the memory. I don't see it anywhere. I would suggest that since a person who voluntarily departs can reapply for readmission at any time in the discretion of the Attorney General, he can simply ask the Attorney General, can I be readmitted and can I go back to Massachusetts and can I fulfill my probation there as part of my readmission? And I would suggest that if that was his inquiry of the Attorney General, probably at that point the court might be contacted, probation might be contacted, we might be contacted, and there could be some discussion around that.
Are you aware of any condition, of any case in which probation has been transferred to a foreign country? Supervision has been transferred to a foreign country.
I'm not aware of any, nor am I aware of any collateral consequence about any impingement on his ability to travel freely about the world due to this outstanding default warrant on the Massachusetts probation event.
Are you aware of anything that might prevent a transfer of probation to a foreign country?
I'm not aware of anything. I mean, I think we'd have to go look at the Hague Convention and the governing documents and the treaties between the countries and see if probation could be transferred. But he could certainly request that and say, hey, please transfer my probation to Saudi Arabia.
So what would you suggest we say as the holding in the case to guide future situations where people are involved in deportation and these, quote, voluntary removals? We say they've got the burden to communicate their plans and they've got to coordinate it with ICE and the courts. Who's got the responsibilities? How should it work?
If you're going to look at and render a holding along those lines, I would suggest the burden is on the defendant, who's subject to the condition to report to court and to be on probation and report to probation. The burden is on them to do the relatively easy step, file a motion with the court to clarify or to terminate the probation before they actually leave the country.
Let me ask you, realistically, does the court have the ability to say, no, you can't, ICE can't deport you, or no, we won't allow you to leave the state?
Under the Supremacy Clause, of course, you cannot supersede the order of the federal government if they choose to remove the person. You can't do that. What the court could do is either terminate and dismiss the probation, which again, the problem with that is then probation is going to cease to be a viable alternative as a disposition, which would be probably a bad outcome. So really what it is holding probation in abeyance is probably the sort of outcome you're looking at, which essentially is all that's happened here. The judge has said you look to be preliminarily in violation. You're not here, you're in default, so if and when you return to the country, you should report back here. The judge issued a warrant. I mean, without that warrant, people can come and go, and they could be in New York, they could be in Los Angeles, they could be in New Bedford. We don't know where they are. They could be here and simply be, ignoring the obligation of probation. Even today, he could be here. I have no idea where Mr. Al-Saud is right now today.
But going back to Justice Cordy's question, it sounds as if there is a difference between deportation and voluntary departure, apart from its voluntariness, in that deportation, the person has no choice and cannot return. So there's no opportunity to hold probation in abeyance because he can't come back. Voluntariness, he can come back. So that possibility is there.
No, you can come back if you're involuntarily removed.
No, right.
You must wait for a period of time before you can ask permission to re-enter. Voluntary departure, you don't have to wait any specific period of time before you apply for re-entry.
Okay, so you're saying that even if he were deported, he would be in violation of probation, even though he had no choice in the matter, and not even the opportunity to. I mean, let's assume he fully challenges deportation, litigates it, loses. He's still in violation of probation?
Well, I think that, if a person is actually incarcerated in the state system and files a motion to get their passport back, they can file a motion regarding the conditions and terms of probation. And so this is also the unusual case. Trying to make a rule about how we're going to conduct business across the Commonwealth in the unusual case, which isn't even ripe yet,
but
which
why
is totally...
Why is it? I mean, people are being deported and voluntarily surrendering who are on probation all the time.
Yes, but it's unusual because, as Justice Cowan said, there's a policy not to take people out of incarceration and remove them.
But he was not. There's certainly not. I mean, certainly they put a detainer on and they await. They don't pull somebody out of jail. But upon the release from custody, in my experience, they take you. I've had INS before me when it was INS challenging the very same thing 10 years ago. And to my knowledge, it has not changed. The federal government will just take you.
You should be aware, of course, there's no record evidence of a detainer here. There's record evidence that about July 20th, they used a warrant to go to the jail in Edgartown, pick up his body, and take his body to Logan to put him on a first-class flight. There's actually no evidence of a detainer. So you have a record here which is really not well developed and not litigated. In fact, if you read the transcript of what happened before Judge Hinkle, the defendant walked in and said, yes, he's technically in violation. If you read his motion to dismiss, he said, yes, he's technically in violation. He conceded all of that. He never raised due process below. He never raised impossibility of compliance in the sense of due process issues. He never raised his lack of presence. The entire brief here has nothing to do with what happened in front of Judge Hinkle. He walked in and said, I'm in violation, but I think you should use your discretion to terminate and dismiss probation.
Mr. Zanini,
Yes.
your time is up.
Thank you, Your Honor.